Good morning, everybody. We're letting everybody in, so and people will pop up on their screen. Um, if anybody wants to say hello in the meantime, please unmute yourself and say hello. Mark's just waving. Audrey's coughing.
Sorry.
It's all right, don't worry.
Hi, Nina.
How is everybody today?
All right, yes. Are you all right?
Sorry, was anybody asking me if I was all right? I can't hear somebody. Anybody? Anybody want to say they're well or not well or whatever?
Very well.
Good, good.
All good as well, Dave.
Good, good. Michael Cover unfortunately can't be with us today. He's on a well-deserved holiday break. Martin Poulter's with me doing the tech as always. I'm grateful to him.
Good morning, David. Sorry it's a bit late. Kevin here.
It's all right, don't worry. No problem. We're not sort of officially started yet, but we're just sort of saying hello to anybody who's already joined us.
Good morning, Eve here.
Hi,
hi,
Eve.
Hi.
We can't see you, but we can hear you.
Yeah, just in an inconvenient place at the minute, but I
Okay, don't worry.
I dialed in. Thank you.
Yeah, that's no problem at all. No problem.
Yeah, lovely to meet you all, though. Thank you.
Thanks. We've got 21 people on so far. Couple of good mornings on the chat. Somebody's disappeared.
Sorry.
Somebody's gone sideways. John H. has gone sideways. He's trying to upright himself. He's righted himself, if there's any such word. We are recording today, although it's going to be informal. Hopefully you will all have seen that our speaker had to pull out at the last minute. So his apologies for that. Hopefully we'll be able to rearrange him, I think probably for the November meeting, but more. It's sunny in Cork, according to Bill. Pleased to hear that, Bill. Got 28 on now. We've got 60, I think 68, 67, 68 booked. Catherine's just arrived. I think, Catherine, you're a first timer.
Catherine or Karen, do you mean me?
Sorry, Karen, sorry, Karen.
I
sorry,
am
my apologies.
Hi.
We
can't get on.
We normally leave first timers to introduce themselves till the end, but I think there are only 5 of us, or 5 of you rather. Perhaps we can do that first, and then we'll have just a very, very general discussion as to anything of interest to anybody, but possibly regarding whether Churchill v. Merthyr Tydfil is bringing along more court-ordered mediation. So first I've got in alphabetical order is I've got Eve Atat. I think I saw you on, Eve. Are you still there?
Yes, I am here.
Do you want to just mention who you are, what you do, and anything else to do with mediation?
So good morning again to everyone. It's Eve Atat. I am a civil and commercial mediator, trained and qualified within the last year. So pretty young and just gaining experience as I go. I currently volunteer for Mediation Box for civil commercial cases. But really lovely to meet you all and looking forward to connecting with you all at some point. Thank you.
Thanks. Where are you based?
I'm based in Milton Keynes,
MK.
but yes, I'm willing to travel anywhere. So yeah, thank you.
Okay, good. Then next I've got Andrew Crombie. Are you with
Hello.
us,
Hi,
Andrew?
Dave. Hi, Dave. Can you hear me okay?
Yes, I can. Yes.
Thank you very much for inviting me along today. And hello, everybody. I've got to say, it's terrifying to be facing the prospect of 40 mediators on a screen. I'd never expected to spend my morning doing that. But I'm Andrew Crombie. I'm a commercial litigator at Waitman's. Been commercial litigating for 34 years. About 60% of my practice is solicitors' partnership disputes, which is what has led me to mediation, because
I love this. I love the sound of that.
it couldn't happen to nicer people, I can tell you.
No, indeed, you could not.
And I'm as fresh as it gets. I had my training 2 weeks ago with ADR Group, and really looking forward to seeing what everybody's up to today. So thank you for inviting me.
That's great. Thanks, Andrew. Then I've got John Hackett. Are you with us?
Yes, good morning. Thank you
Hello.
also for inviting me. I'm very interested to be part of this breakfast group this morning. I've been the lead mediator in the National Crime Agency, which is part of the civil service, for about 14 years. We're very ably supported by the Civil Service Mediation Service, which provide really good practice for us, sort of in-house, if you like, and we've got a lot of good contacts now around the sort of supervisors within mediation and in the civil service. But I've recently, as a result of the CSMS, actually was part of the CMC meeting on the 13th of June, which is how I got the contacts for this. And it's just fascinating to see how it operates outside of the civil service. And obviously I've got an eye to the future as well. I'm also based in Milton Keynes, Eve, so I'd be very keen to link up with you for a coffee at some stage.
Yes,
but
please.
no, and I'd be very interested in the Buckinghamshire volunteering as well, to be quite honest with you. So yeah, I'll shut up and let everybody else get on. But thanks again, Dave, for hosting this.
Thanks, John. Then I've got Judith Hogarth.
Yes, thank you very much, Dave. And like everyone else, all the other newbies, I'm delighted to be here today. So I'm an employment solicitor, and I've been practicing as a workplace mediator for 15 years. But like a few of the others, I've just qualified. I'm CEDA qualified now in the commercial area. And so I'm really looking forward to diving into that field as well. So I'd look forward to meeting everyone in due course.
Thank you very much. Do you prefer Judith or Jude?
Jude is great. Thank you.
Yeah, okay. I presume that CLA mediation doesn't stand for Country Landowners Association.
No, not at all. No.
Okay.
So so there are 3 mediators, and we have combined together to just further our interest, but that's on the employment mediation. So that's what I'm here independently of them today.
Okay, thank you. Next I've got Maddie Meredith. Maddie, are you there?
Hi, good morning all. Thank you again, Dave, for hosting this today. So my name's Maddie, and I'm currently interning and attending on behalf of Essential Mediation Solutions. I started volunteering also for Mediation Bucks about a year ago, but Eve, I don't believe I've had the pleasure of meeting you yet. But yes, I've just finished my law degree at the University of Bristol. So I'm fairly new to mediation. I did the workplace training about 2 months ago, and yeah, really enjoying it.
Thank you. Was mediation part of your degree course?
No, it wasn't. So I volunteered in the law clinic, and as part of that, we did a module called Clinical Legal Studies. And as one of our seminars, we looked at ADR, so we covered mediation briefly in that sense. But no, it wasn't part of the course.
Okay, thank you. I've got Lorraine O'Keefe, but I think she can't make it. I don't think you're there, Lorraine, are you? No. Okay. Shall we kick off then with whether Churchill v Merthyr Tydfil?
Sorry, hello, hi, it's Karen. I didn't get to say
sorry.
hello.
Oh, sorry. I'm sorry. I forgot I hadn't got
okay.
you on my list until the last minute. Yeah, sorry.
Sorry, apologies. That's my fault for being very last minute.
No problem.
My name's Karen Jones. I'm an insolvency practitioner, and I actually do recognise a couple of faces on this call from my many years in the industry. And I have more recently just been looking at acting another string to my bow. I do a lot of commercial insolvency, a lot of corporate stuff. There's a lot of shareholder disputes and various things where actually having the training and the experience from mediation would probably assist very much in what I do, and fitting very nicely with my network. So I am now exploring doing that and hopefully becoming qualified as soon as possible.
Good. Thank you. Sorry I missed you out.
That's okay. No worries.
Is there anybody else here for the first time that hasn't spoken yet?
I don't think I have, Dave, and thanks for organising this. It's Beverly Sayers.
Hello, Beverly.
First time I've been along to one of these, but I'm not a newbie as such. So I'm mostly a family mediator, been mediating for over 30 years in the family mediation field, but also civil and commercial trained with Henry Brown about 20 years ago, and do a small amount of civil and commercial work across the country.
Thanks. Where are you based, Beverly?
I'm actually based in the Northwest, but I mediate across the country, both mostly for civil and commercial cases across the country, but also for family cases where they pay, if they're interested in paying me to travel.
Okay, thank you. Anybody else who's a first timer? No. Okay, so if we
Dave,
sorry.
before we start, I should just say that I've snuck in on this meeting. It's Ian Whittick here.
Yeah, yes. Hi, Ian.
Hi, I was junior counsel in Churchill and Merthyr. It was my idea.
Well, I'll throw it over to you then to tell everybody, because not everybody will be UK based, what the discussion was, the problem and the outcome. If you want to try and do that in 2 minutes, if that's possible.
I'll have a go, Dave. Yes.
Yeah, please do.
Well, hello, everybody, both in England, Wales, and the rest of the world. I am a property barrister in Bristol, and a lot of the work that I do is defending various public bodies against claims farmers, ambulance chasers. So as part of my work for Merthyr about 20 years ago, I defended about 250 housing disrepair claims, housing conditions claims as they are now called, and we defended them on the basis that tenants should go through an internal complaints process before suing. The district judge liked that approach, and we did 12 test cases out of the 250. The district judge gave summary judgment to us and struck them all out. So both on the grounds that people should go through the internal complaints process, and also on the grounds that they were unmeritorious cases anyway. Cut to 2022, and Merthyr came back to me because they remembered what I'd done back in the day, and they said, well, can you help us with this claims farmer who has sued us for Japanese knotweed incursion? And I said, yes, we'll run the same argument. And I have been running that argument for about 20 years for housing providers, for social landlords all around the country. And we ran it at first instance. The judge in Cardiff said, well, I think that the claimant solicitors have been completely unreasonable refusing ADR, but Halsey against Milton Keynes Area Health Authority is against me, and I can't force them to drink. I can lead the horse to water, but I can't force it to drink. So I can't stop your case. And I'm going to say that while you had a very good argument on the facts and the claimant solicitors have been unreasonable, I can't stop the case and it will have to go ahead to trial. We appealed it and went straight up to the Court of Appeal. We leapfrogged past the county court with the agreement of the county court judge. And anybody who's read the decision will know that then we had 7 interveners join us, and we had a 3-day hearing in November. at which the court said unanimously that Halsey never it really said that you couldn't force people to mediate, because the pronouncements by the judge on that occasion were obiter dicta. In other words, they weren't part of the main decision. And so for all these years, people have been following Halsey, but they needn't have done so effectively. And Halsey was overturned. And as you're probably aware, if you're practicing in England and Wales now, you can apply to the court to stop proceedings. And that's just what I've carried on doing. I'm still getting huge arguments from my opponents, but that's not surprising, because if I win this war, then they're finished. They are, as ambulance chasers who depend on going to court and getting their costs back, I'm going to go into liquidation en masse. And on that score, yesterday I found that McDermott Smith, who were the solicitors on the other side in that claim, have indeed gone into administration. So that's probably as a result of this case, because they would have been expecting to recover their costs in hundreds of Japanese knotweed claims and also housing disrepair claims, and they are now going to be forced into internal complaints processes. So it wasn't about mediation. The interveners made it about mediation, and the Court of Appeal made it kind of sound as if it was a lot about mediation, but it wasn't at all. It was about free, non-lawyer based internal complaints processes. So Dave, I hope I've at least introduced it.
Yes, that's very kind. Thank you. Actually, Michael Bartlett has posted a question. Does anybody have an update on what's happened since the CA? So you've given partly an answer to that. But do we know whether the parties have now gone to mediation or are proposing to go to mediation?
No, they're not. There's been an interesting development, because the Court of Appeal completely, in my view, wrongly said that the internal complaints process shouldn't now be tried because the parties were too far apart. Well, the only reason they were too far apart was because claimant solicitors had dreamt that reason up. And they said it was all too far down the road. But the council's gone to another guy in Bristol who has taken a different tack to me, and he's agreed with the other side that there should be a joint experts report. Now, at the same time, the Supreme Court decided Davies and Bridgend Council, and I don't know whether anyone's familiar with that, because that's a Japanese knotweed claim, pure and simple. It had nothing to do with ADR. And the Supreme Court said effectively that all these Japanese knotweed claims, if there was knotweed on the property more than 6 years ago, then they're all out of time, they're out of limitation. So no damage can be proved within the limitation period, and the cases are worth nothing. So at the same time, the expert evidence on all these Japanese knotweed cases is going to be, well, yeah, this knotweed was on the property more than 6 years ago, and therefore there's no claim within the limitation period. End of the claims. So that claim, Churchill, will bite the dust, and with it, all the others that haven't been referred to ADR. And there are implications, obviously, for any other form of legal claim involving incursive vegetation. So there's other stuff that invades that they would probably have been developing as a litigation weapon against public bodies, and they will no longer be able to do that because they won't be able to prove that it was on the land only less than 6 years ago.
That's great. Thank you very much, Ian. So coming back to the overall question, is this case now producing lots of court ordered mediation? I've had a couple. Has anybody had some that have been court ordered since the judgment? If people can just put their hand up, please, electronically, if it's easy. Ian, you've got your actual hand up anyway, and I'll come on to you, Kevin, in a second, please.
Did you want me to tell you about what I've done?
Yes, yeah.
I have done dozens of applications to stay proceedings since, and we have been mostly successful. The only times we haven't been successful is when we've already been through stage one of the internal complaints process, and the judge says, well, there's not much in this claim. Let's just get on and do a small claims trial hearing.
Right.
And so most of them are being stayed. I have yet to have any struck out for a total refusal to stay. Total refusal to engage in the internal complaints process, because every single tenant so far has engaged in the process. So I haven't had the tenant saying, my solicitor has told me not to say anything to you. And there would be an interesting parallel in mediation if people were to turn up to the small claims track mediation service and say, my solicitors are telling me to refuse to say anything here because it's not going to give me anything. It's not going to give me the relief I want or anything like that. But I reckon that most district judges will just squash people who try that line, will just say, oh, I'm not having that. You've got to try in the mediation. You've got to actually engage with the mediator.
Yes, I think get engaged was the actual word used in the case.
Yes, well, that was the whole. I mean, that thing about leading the horse to water was actually. I can't remember which silk used the phrase, but they did say, well, actually, you can not only lead it to water, but stand there and wait until it drinks. I think it's a really good analogy that if you use proper pressure, any dispute should be capable of being taken first to, in the case of a public body, to an internal complaints process. And then if that doesn't work, to mediation. And that is exactly what I will do when the small claims mediation service is better established. I will be using that after we've gone through the internal complaints process. I'll be saying, well, it's still not ready for trial. It still shouldn't go to trial.
Yes. Graham's posted a question. Who was the council turned to, Ian?
That's a guy called Ewan Payton.
Right, thank you.
The other knotweed claims, and I've done, I don't do knotweed claims, I do housing conditions claims, housing disrepair claims, mainly.
Thanks very much. Kevin, I think you had your actual hand up, and then I'll come on to people with their virtual hand up. Kevin Smythe.
David, yes, good morning, and good morning, everybody again. Yes, I have had a referral now. Parties have signed up to a mediation agreement. I don't yet know a lot about the case, but I was told by one of the solicitors, indeed by both solicitors, that it's a court-referred mediation. It's a property case. It involves breach of contract allegations. I can't say more than that at the moment. I haven't seen the documentation, therefore I haven't seen, or I'm looking forward to reading the order that was made and the words used in terms of referring the case to mediation. Of course, everybody be aware of the fact that the Court of Appeal scheme is, I've always thought, to be almost an enforced mediation order, if you could call it that. There is the pilot scheme of the Court of Appeal, and there are a number of cases that have pushed the mediation way with a very heavy hand. That's been the case for a long time, way before Churchill, and indeed not so long after Halsey. And I do a number of those mediations. Indeed, I have one on at the moment.
Thanks, Kevin. Right, in terms of hands up, Susanna Ingman.
Hello.
Hello there, hi.
Good morning, everybody. So I'm Susanna Ingman. I'm based in North Devon. I'm a community mediator, and interesting from what Ian was saying, I'm also on the board of a housing association. So quite interesting there. But my point is, in terms of approaching the courts to see how the local community mediation can assist courts and small claims going towards mediation, we've been completely rebuffed and being told your services, aren't required, and we're just going to go through this. I think it's the 1 hour telephone mediation compulsory activity. So the question to the group as a whole is, or anybody, is, has anybody had successes in overcoming this impasse of, we spoke to a local judge and we were really blocked from being engaged in this activity, which just seems a real shame, unless I'm being very naive. Thank you. So that's my question.
Thanks. Would anybody like to try and pick that up? If you can put your hand up. Ian, yeah, okay, Ian.
I mean, I'd like to hear other people on this question, but I have had 20 years and more of it. And it is entirely dependent, I think, on the judge's attitude to litigation and lawyers. And it is quite easy to see that some judges just want lawyers to make livings out of legal proceedings. And if they're in that frame of mind, and if they are completely kind of lawyer-led, and their entire approach to life is one of seeing the law as a way of making a living and of really, I suppose, just everybody should bow down to lawyers. That is where I find I get people who just say, well, they'll think of excuses and reasons why a case shouldn't go to ADR, and then they'll justify them with some warped view of the facts. But a lot of the time, it's a question of getting people to see that you're not unreasonable about what you're asking the court to do. And in my case, it's to cut the lawyers out completely. So it's to cut most mediators out as well in the first instance. And then if that doesn't work, then engage people who are expecting fees. But where a court is being difficult, it's normally because there's some stick-in-the-mud judge who wants everything litigated and wants their court used. And there are all sorts of hidden reasons behind that refusal, I would have thought. I'll give you a good example. One of them is that I'm having a battle royale all over the country in the question of whether we should do remote hearings. And some judges say they won't have remote hearings because they want their courtrooms and their court staff used. And so they want people there. But there's also a bit of judgeitis there. They want to be controlling the 10 litigants that are there for that day's hearings, and they want to have them all in person running around after them. And so there is a huge psychological thing going on, as well as more subtle stuff about the usage of court buildings and court staff. And you need to address that somehow. I don't quite know how, but Suzanne, I expect that you will have a judge there, a local judge, who is against ADR because they want the courtroom used. That's a penny's worth.
Well, that's good. Yes, thank you for that, Ian. That's an interesting point. Perhaps we have to do a bit more relationship building. I think you're right. So thank you very much. Good perspective.
Camilla Palmer, you've got your hand up, electronic hand up next. Hi, Camilla.
Hello. I'm a judicial mediator in the Employment Tribunal, and all the mediations, and there are a lot of them, are online, and that I think it works very well. So there's no question of going into the tribunal, or as you suggest in the court. The one issue is, and I don't know whether any of you come across it because you all represent the parties, is what to do with litigants in person who have no access to advice, because some litigants in person will say, well, I don't know what to settle for because I don't know the value of my claim, or whether it's a big claim or not. And I think there is something possibly in one of the protocols or the proposals that may provide that help, but it may not be relevant for anyone else. And then just finally, in the employment tribunal, there is now mandatory mediation, but it happens right at the end after exchange of written statements, which means that an awful lot of costs are incurred before it gets to that stage of mandatory mediation. So a different system, I suspect, to the employment tribunal. I mean, to the ordinary courts.
Thanks, Camilla. Kevin, you've got your hand up now.
I think I'm off mute. Yes, I am. Following on from what Ian was saying in regard to judges not making orders, and he used the word or judgeitis. It does. I'm no longer in practice as a solicitor, so I'm not appearing in court any longer. But I have to say, I would be very sorely tempted in our local county court if that was the view that a judge took, i.e., the view that a case should not be referred to mediation in circumstances when one felt that it should. To add the comment that it's an absurdity for the county courts to have the delays that they have with periods of a year, 12 months, of course, a year, 18 months for a trial date, because they don't have the capacity. And they don't have the capacity because they're not having the powers that they have to manage cases appropriately. And insofar as court-ordered mediations are concerned, what better reason could there be in the right sort of case but to refer a case to mediation that cries out for mediation and free up court time and resources? And I think that local law societies should bang the drum. I think the Law Society perhaps should bang the drum. The Bar should bang the drum. And hopefully the new government may, or the Ministry of Justice may start banging that drum as well. It is an absurdity to think in terms of the delays that there are because the resources that there are available not being used. And one, of course, is now court-ordered mediation. And of course, online court hearings and mediations.
Thanks, Kevin. Martin's posted a question. Where are we with the CPR rule changes from the case? Would anybody like to pick that one up?
My understanding from Tony Guys, who seems to be the LinkedIn expert on this, is that the closing date for comments has passed and they're being considered. That's not very helpful, but I think they're still working on them.
Yeah. Thank you, Gerard. I think, well, I've understood that the Bar Council has endorsed the proposed changes. So
yeah, there was more of the general feeling was they're a good idea. I've seen one or two people dissenting.
Yeah.
I'd be surprised. What do I know? But I'd be surprised if they didn't go through pretty much as drafted.
Yeah. Anybody else want to carry on this topic with any other thoughts or questions?
Can I just say that, as I understand it, the proposed amendments are going to be accepted without any substantial change. And that is unfortunate in the sense that the one change that I thought should be made was that the power to do more than just make a costs order against someone in the event of a refusal to engage in ADR should be made clearer. And I would prefer that it said something about the court being able to strike out a claim because judges are often reluctant and claims farmers use that reluctance to manipulate both the court and the proceedings. So I don't think it's going to happen. I don't think that amendment is going to be made, but maybe in the future we'll be able to improve on what's there, because I see people being able to get around the wording pretty easily. And actually, just on that score, I've looked back through the chat and I've seen what people have said about costs penalties for refusal to mediate. I did a hearing last Thursday in which I said that the claimant solicitors should be paying all our costs on an indemnity basis rather than the claimant themselves, because the internal complaints process had resolved the issue for the tenant. We had asked the claimant solicitors not to go any further with the litigation when we first got a letter of claim from them, and they'd ignored us and then eventually conceded defeat. And the internal complaints process had indeed resolved all the tenants' concerns. So we were arguing that they should pay our costs personally, and that they shouldn't do what they normally do, which is when they lose, they chase the tenant for the costs. If the tenant refuses to carry on with the proceedings, then the tenant gets a bill for 5, 10, 15, 20,000. So it's pretty serious stuff. And we'll see what happens, because the judge in that case has reserved his judgment. But those people who are posting and saying, well, I've got a small sanction in terms of reduction in costs, I would go much further personally. I would say that you should be pushing for different orders for costs. And if you look at CPR 44.2 and all the case law, there's a lot of support in the authorities for different costs orders, particularly if your client has said right the way throughout, this dispute should not be litigated. This dispute should be resolved through ADR. But we'll see how the rule changes pan out. I'm optimistic that it'll be a huge increase in referrals to ADR.
Well, we've been all thinking of that as a false dawn in the past, so it'd be nice if it comes about. Beverly says you've got your hand up.
Yes, I just wanted to give a little bit more hope to Suzanne. And following on from what Ian was saying, which I think is absolutely right about some judges having judgitis. I've also had the arguments that once they're in court, we might as well sort it out there and then, sort of thing. But I do think very genuinely one of the things that is valuable is that it is difficult for a court to refer to just one mediation organisation. And we have found some success in a number of mediation organisations clubbing together to produce a leaflet, which then the courts find very difficult to say, we won't have there, we won't, that they then, because it is a number of people, they can't have that argument that they can't promote just one individual. But the other thing is, I do think there is a great value in networking and getting to know the local judiciary. I think that works wonders.
Thank you. Anybody else with any thoughts or questions on this topic before we move on?
I put one in,
Michael.
Dave.
Yeah, hi, Michael.
To Ian and everybody who's had a Churchill order, I think they're going to be called. And the question is, now that they are being made, and Ian, you said you've had a few where you've got stays. In Churchill, the Court of Appeal said, we're not going to give a checklist of the criteria that judges will use, because judges are smart people, even if they have judgitis, and they will work it out for themselves on a case-by-case basis. But I'm just wondering, are there any principles now emerging? Now we're getting these applications and these orders. Are there any principles emerging now? Can we see a pattern? Because I've got one that's, we don't know. We're thinking of going for a Churchill order. I have to say to them, well, we just don't know what the criteria are. It's a case-by-case basis. But now there seems to be a few dozen coming along. Are there any principles emerging?
Ian, do you want to? You've got your finger up, I think. You're muted, Ian. Ian, you're muted. You're still muted, Ian, if you're wanting to.
There we are.
Yeah.
You can hear me now, I think.
We can hear you. Yeah, we can hear you now.
I thought that was quite funny because Geoffrey Voss said, oh, I'm not going to give a checklist. But then if you look at his judgment, it's a checklist. But there are about 13 factors he's managed to dredge up that you have to consider. And it is, I thought it was the most wonderful piece of legalese, because there he was saying that he wouldn't mandate, but that's exactly what he has done. And if you want me to, I don't know whether I can screen share here and show you the judgment, but there are a number of paragraphs where he talks about what sort of things should be considered. And he also refers to the Bar Council's checklist, which itself was based on what they were saying in Halsey about when parties should have to pay cost penalties for unreasonable refusal to mediate. So there is a checklist. You can go through it. I used it in an appeal in Luton last month, and the judge there he thought it was a good list, I think, and the way that we used it was quite effective. And that case has gone back to the district judge in Slough and Reading for reconsideration of the question whether the claimant should be forced to go through the internal complaints process. But we've also got summary judgment against the claimant in that case on most of his claim. So the claim will bite the dust anyway. But the important point is that the district judge in Slough and Reading will now have some guidelines that he or she can apply, and we'll see whether the claim will be stopped. But I think it's capable of being reduced to witness statements, setting out the benefits of ADR and setting out your particular process, and then you make the application to stay. Should be fairly formulaic in the future.
Thank you, Ian. Michael Bartlett, you've got your hand up.
Thank you. I'm really wondering about some of the unintended consequences of Merthyr Tydfil. I mean, one of them's already been alluded to, that Merthyr Tydfil concerned internal complaints processes rather than mediation, and more internal complaints processes don't necessarily translate into more mediations. You could paradoxically have more internal dispute resolution mechanisms then followed by more litigation. But the other thing that really interests me, and I'm fascinated in straws in the wind and what people think, is more mandatory mediation going to mean that it is lawyer mediators who do the bulk of this, or is it going to be equally favourable to non-lawyer mediators? The reason I'm saying this is not simply as a matter of principle, but generally the closer mediation is to the court, the more that mediation, I suggest, tends to mirror court processes. And I'm wondering just whether anyone has any views on it. Merthyr Tydfil may be good for mediation. Is it good for non-lawyer mediators?
Yes, Ian.
I'm sorry. You must just shut me up if I'm saying too much. But the answer is that is a market that you can make, but it is more difficult for you to break in because you're not physically present in the court buildings, and how you advertise your services to litigants who are there is a good question. I mean, you can be really blunt and look at court lists, see who's in the courts, and find out the names of the companies, and then email them and say, I see you've got a dispute. Can I offer my services as a non-lawyer mediator? Because you are up against, if you're a non-lawyer mediator, you're up against the lawyers, and they are very keen to get in there. What's said in Churchill shouldn't make any difference to the question whether it should be a lawyer or a non-lawyer mediator. But for my part, I must say, I am a massive fan of specialists in the field I'm dealing with. So, for instance, when I do property mediations, I absolutely love having surveyors as mediators because they're not trained Rottweiler litigators. They are trained to solve problems. And I'm a fantastic fan of mediation and anything ADR oriented because it deals with wants and needs and not pure legal remedies. And that is a again, another good reason why you non-lawyer mediators should be pushing yourselves and saying, I think creatively, I think outside the legal box, and come to me and we'll see if we can find a solution that doesn't involve just numbers and worse costs. So I would say, I would encourage you and say that Churchill is good for anybody involved in ADR. And that's another aspect of it that wasn't made clear in the judgment, that I really see ADR as a continuum of increasing seriousness and expense. In big cases, there is nothing wrong whatsoever with starting with an ICP, going through that, going through an attempt at mediation, sorry, at a JSM or a meeting between lawyers, and then moving on to mediation, because a good mediator in a commercial property dispute will be 5,000 or 10,000 quid a day, and you don't want to spend that unless you have to. But then I know mediators, I see people like Jared there, I know mediators who do property work who earn their money because the 5,000 in fees or whatever is translated into a settlement that could never have been reached by the parties when they're on their own, just bickering between themselves in a meeting. So I'm a great fan of Churchill, the way it's been put, but use it, look at it and use the words that Geoffrey Voss used in his judgment to your advantage. That's how I'd put it.
Thanks, Ian. Any more thoughts on this topic? Can I therefore invite anybody who operates outside the UK to give any thoughts on anything at all? Bill, you're based in Cork and Dublin, I think, and are you still on, Bill?
I'm still here.
Yeah. Is there anything, partly reflect on what's been said in your jurisdiction, or anything else that we should learn from that you're doing?
Churchill has certainly grabbed the attention of the ADR practitioners in Ireland. Mm-hmm. We have a statute since 2017, the Mediation Act 2017, but up to now, very little case law. The UK has a great body of case law and very little statute. There's a statutory obligation under Section 14 of our Mediation Act 2017 on lawyers, both solicitors and barristers, to advise in writing in relation to the advantages and benefits of mediation before commencing legal proceedings. Now, I'm actually doing a doctorate through Northumbria University, and it's on the topic of the attitude of Irish solicitors towards mediation and the extent of their knowledge about the subject. And the headlines, the vast majority of Irish solicitors have an awareness of this fuzzy, cloudy thing called mediation, and will happily sign, as required by the Act, a statutory declaration as to having advised the clients all about it. But when you actually drill down into it, they do not know what the obligations under Section 14 actually are. One former president of the Irish Law Society, whom I interviewed and has a large litigation practice, freely admitted that in the 6 years since the Act came online, nobody in his practice had actually complied with the obligation. And I advised him as to the potential consequences, i.e. the court would stop the proceedings dead in their tracks and say, sorry, if you did not advise before the commencement of the proceedings, these proceedings cannot continue. You can start again. If they did comply but simply failed to file the statutory declaration, the court can stay the proceedings until the declaration is filed. But I have successfully applied in 2 cases to have the proceedings stopped dead in their tracks because of failure to advise before commencement of proceedings. One of those, the case was then statute barred. I put in the post or in the chat a link to an article I've done for the Irish Law Society Gazette on a recent High Court decision here, where a judge at hearing said, and it's a solicitor judge of recent appointment to the High Court and who was an ex-member of the ADR committee of the Law Society. So the first thing he did when the case was open said, everybody stop a minute, where's the Section 14 declaration? Confirmed that it hadn't been filed, so he rose to allow compliance with the obligation to file the declaration. that being in circumstances where the solicitor in court said, yes, I did advise before commencement. He then imposed a 5% cost penalty for having failed to file the declaration. When granting costs, he limited the recovery of costs to 95% of the plaintiff who was successful, but warned he was being very lenient in this particular case, and it should serve as a warning to others. And I've also posted a reference to a UK county court decision where there was a 25% penalty for failure to engage. All of that is now being frontlined. The Law Society Gazette front cover article this month is warning solicitors in relation to that. But the vast majority of Irish lawyers have yet to get a slap in the face with a wet fish in terms of a costs order because of their failure.
Thanks, Bill. That's interesting thoughts. I've got Kat Ballinger. It's based in Portugal. Are you with us, Kat?
Hello, yes, I'm here. I'm with you. I actually don't have any update from Portugal because I have yet to get off the ground with my mediation practice. But as I'm listening to everyone talk, because I'm a former practicing barrister, so I come from that perspective, and actually from the perspective that the justice system, can't say it doesn't work, but I think it has a lot of issues. And from doing my mediation training, I feel really, really positive that mediation is a far better way of resolving conflicts. And the more I listen to people speak, and the more I listen to this discussion, the more to me it seems to make sense for there to be mandatory regulation. And I'm wondering, I don't know the history, unfortunately, I'm new to this area, but why is mediation an area that isn't yet regulated? Because I wonder whether this is part of the court's reluctance in really making mediation a more formal part of the court process. I'm sorry if that's a really ignorant question, but there we are.
Anybody like to pick that one up?
I think it's a really good point, Kat, and I don't know if many of you are aware of the MOJ consultation recently, which actually wanted to make mediation compulsory in the family courts, and the family mediators fought against it because and advised against it, and it hasn't been instigated as a compulsory expectation. Expectation is what it has remained as, although the MOJ are saying they are still considering whether it should become compulsory. And the main argument that the family mediators made was the power of the voluntary nature of mediation.
Dave, you may know from your CMC connections and network more than I do, but I think it's coming. So regulation is coming, but the CMC are talking about doing it still on a self-regulatory basis, but tightening it up. So it is going to happen. People I talk to in mediation world say it's coming. If we're going to make it mandatory, if we're going to offer it to the public on a more formal basis, there has to be some sort of regulation. I've got mixed views about it, but Dave, from your CMC meetings and anybody else that's on the CMC or on the CMC committee here, that seems to be right, isn't it? They are encouraging. They're talking to the MOJ. They're talking to government about it. It will happen. Discussions are already underway, but it won't be like the Bar Council or the SRA. There won't be that sort of standard of regulation, but there will be an understanding that we have to self-regulate on a much better basis than we're doing at the moment, which is zero. Well, semi-zero.
Yeah, as I read it, in terms of the CMC, it just doesn't have the capacity to regulate in a full sense of the word as the Law Society or the Bar Council, and relies on effectively delegating that down to the providers that it accepts on its list of accredited mediator panels.
I am.
Just before you come in, please. Paul Adams, the CEO of the CMC, is hopefully going to be our speaker at the next meeting. I'll come back to that in a minute, so hopefully he'll be able to give an update then. Sorry, Beverly.
No, it's fine. I sit on the board of the FMC, and family mediators are well regulated. It is voluntary regulation. And I think that the government, the MOJ, has ongoing and extensive discussions with the FMC because of that regulation. I know that the CMC and the FMC are liaising quite a lot with regards to regulation. There is an accreditation system that is undertaken, and in fact, the government requirement to attend an initial meeting with the mediator came about because of the MOJ's recognition of that accreditation and regulation, that the voluntary regulation that the FMC holds.
Thanks, Beverly. Michael, you just posted a question. Maybe you could actually pose it online or in person now.
I may be mistaken on this. I've been very impressed by a judicial mediation in the employment tribunal, which I supported a friend through. But my understanding is, and I may be wrong, that that's a distinct process from mandatory dispute resolution. But maybe Camilla can fill us in on that. I may well be mistaken.
It's developing at the moment. In the ADR judicial employment system, but it is, you're right, it's a dispute resolution appointment, which is fixed for about 2 or 3 hours, but during that appointment there is the possibility of trying to reach agreement between the parties and to encourage them to go forward and have a judicial mediation or other mediation. So it hasn't moved on yet, but I think probably it might do. I think there's still some sort of, the problem is there are an awful lot of litigants in person, and it's quite difficult to force mediation on a litigant in person if there's no access to advice, because what they may say is, well, we don't know what the strength of the case is and we don't know what the remedy will be. And I think that is an issue for all the courts. And I think I've read something saying that there may be some advice provided before a mediation, but be interested to know if anyone else has information on that.
Ian, you're back on, but muted.
Yes, because that really interests me. What Camilla's just said is a huge part of the push towards ADR, which is that when I either do mediations as a mediator or I do mediations as an advocate, I tell my clients to stop focusing on whether they're going to win or lose and start thinking about what their needs and their wants are, and just throw everything else out of the window. So you don't need to know whether you're going to succeed in your claim. It's totally irrelevant. You might have 110% chance of winning. You might crush the other side with a wasted costs order, but does that really get you anywhere in life? No, quite frequently, it gets you a massive amount of stress. You probably end up, even with indemnity costs, having spent 5 or 10 grand at least on the claim. And certainly you would be a hell of a lot more stressed than you would have been if you just knocked it on the head in an early mediation. And so even if you're against a dishonest thug, and in property cases, I have on many occasions been against people like that, I still say there's absolutely not even no harm in trying mediation. It's an essential part of it. And I think for that reason, if we could get litigants in person with a sheet that explains in black and white why you don't need to worry about whether you're going to win or lose and whether you've got the best evidence, you would have a much higher chance of persuading them to look at mediation or ADR in general in a totally different way. And a much more positive result would come from all those litigants who say, oh, I'm not happy with letting some outsider deal with my dispute.
Can I just come back very briefly? I think you and I know that, and when I'm doing judicial mediation, that is what I say to the parties. But claimants don't need that, necessarily know that, and they want to know the value of their claim. So it's all very well what we know and we do, and I totally agree with you, but that is not my experience necessarily of litigants in person who, and just one other thing I would say, that the process in the employment tribunal, compensation can be reduced if the claimant has not already filed what's called a grievance. So it's an internal process, which is actually really harmful because all it does is ratchet up the dispute because the employee makes allegations and the employer defends them, and then they are daggers drawn, as it were. So one thing is that any internal complaint process does have to be about resolution and solutions, and not who wins and who loses.
I think there are two things I would recommend there. One is the potential for evaluative mediation, and the other is just a statement about how to present your case to the other side. And I'm thinking about saying things that telling litigants that they mustn't use inflammatory terms. They must just stick to their grievance and try to keep a lid on things. But I mean, you're quite right. The problem is that they can't receive good, coherent legal help at an early stage in order to steer them. But for that reason, again, I just think that if there was some simple noddy sheet in which you could explain to them that life is not all about a win in court, and indeed a lot of people's lives are ruined by a win or a loss in court, and it would make a huge number of disputes which currently end up at trial at least have some hope of settlement in ADR. But I agree, there's nothing worse than a litigant in person who's just off the leash and doesn't know when to stop and doesn't know how to proceed. It's a bit insoluble problem.
Ian, just picking up your point, you probably know that the RICS, the Royal Institute of Chartered Surveyors, only now accredits evaluative mediators. So
I did not know that. No. No, my latest news from the RICS was a fantastic, urgent newsletter that came out to all its members saying, would people please stop providing reports for the courts that are not based on fact and appear to be hired gun and so on. It's a joy to read, and that comes from disrepair litigation, incidentally. But if they're offering evaluative mediators, then that's exactly where I think we should be going. And Camilla, the problem is, of course, that there are many areas of law in which those bodies do not and cannot offer a service like that for anything like a reasonable fee. So,
MacDonald, you've got your hand up, I think.
Yes, David. Thank you so much. A lot of good things have been said in answer to the question that Catherine asked about why is mediation not regulated, but I'm not too sure if Catherine has got an answer to her question. It is true to say that we cannot have a satisfactory answer now, But I recollect that some time ago, probably sometime a year or two ago, there was a debate in honor of David Richbell. And at the center of that debate was the issue of, why is mediation not regulated? And much of the argument was that if you make it mandatory to the extent that people will be regulated, it will not be very good. Others were against it. Some said that it's necessary for it to be regulated. But I think for now, I do not know whether Catherine is aware that most mediation organizations have codes of conduct. And there have been instances where mediators have been disqualified from membership of organizations because they breached the code of conduct. And so to an extent, there is this development emerging that even if we say it is not regulated, to an extent, it is regulated because people are abiding by codes of conduct. And as things move progressively along the lines of us having mandatory mediation, I'm pretty sure that some form of regulation will be in place. And so for now, let's bear in mind that most mediators belong to organizations that have codes of conduct, and they have to abide by those codes of conduct in their day-to-day mediations. And that in itself is a form of regulation. It's not a situation where people can just go and say, I'm a mediator and you do what you like. There are codes of conduct and professional expectations from mediators. Thank you.
Thanks. We've got a couple of hands up. I'm conscious that we've just gone beyond 10 o'clock, so everybody's earned their CPD hour. Can I just do a few notices, and then I'll come back to the people who've got their hands up in case people want to go. Firstly, the next meeting is penciled in for Wednesday, the 11th of September. As I said, Paul Adams, hopefully the CEO of the CMC, will be our speaker. Then there's a Media as Peer support group meeting on Wednesday, the 14th of August. Hopefully you've had a flyer for that. If not, if you can let me know. And lastly, there's a mock mediation on Wednesday, the 20th of August in central London. Again, if you haven't had the flyer for that, if you let me know, please. Right. Well, if anybody wants to just carry on, you're more than welcome to stay. Michael, you've got your hand up next.
Thank you. Very briefly, I was interested in the chat. Beverly had referred to an early legal advice project, and I was both wondering whether she could tell us a little bit about that, because I think it's fascinating. And I also wondered whether, if there is an overrun, whether anyone here has experience of judicial early neutral evaluation, which also seems to be a kind of undervalued and maybe underused form of ADR, and would really value anyone's experience on that if they have it.
I can talk about just very briefly on the evaluative judicial mediation. I did one recently, and it was really helpful because I was able much more, not to give advice, of course, but to give much more of an indication about the strengths and weaknesses of the case, because it was an evaluative mediation. And that's particularly helpful for litigants in person who are always asking me as the mediator and an employment judge what their advice, which I can't give. So I think that evaluative mediation is very good. And that does happen during the dispute resolution appointment, which is mandatory, which is a 2-hour appointment with an employment judge. And I just would say the employment judges are very keen on mediation. They are all trained. No one gets to do judicial mediation unless they're trained and they have observed.
Can I just mention about early neutral evaluation? I'm on the council of the Academy of Experts, although I'm a non-practicing expert. And if it's a technical issue, then there are several members who can deal with early neutral evaluation on technical aspects of a case. Tabitha, I think you got your hand up next.
I have, and thank you very much, Dave. And sorry, my camera for some reason isn't working today.
No problem.
I'm really interested. It's a bit of a gear change, sorry, but still off the back of the brilliance of Churchill and with a new Prime Minister and a new Attorney General, does anyone know whether we're expecting new messages or different messages from the government about mediation and the significance it has to a slightly decimated court system?
Would anybody like to pick that one up?
No, I just wondered if anyone knew. I'm just interested if there's been any sort of...
Tabitha, I've had my ear pretty much to the ground and I have not heard any positive signs. You can't buy back all those court buildings that have been sold, and those that are falling down, well, they better start plugging the gaps pretty soon before we start being crushed by large lumps of render and concrete.
Thank you.
I did want to just say something about judicial evaluation, and that is that I have experienced that informally and formally in the past, and it is quite a risky thing because unless a judge is a specialist in the field, then there's a danger of them shooting from the hip, and it doesn't, for some reason, it doesn't come out like it does in mediation, when a mediator might give a really subtle steer. Judges don't seem to be able, or they're not as good at giving subtle steers, and it ends up being a kind of, you walk out of court and you say to your opponent, well, that's the end of your case, isn't it? And it shouldn't really be like that. I don't think ENE shouldn't be like that. It should be much more subtle, much less of a brickbat over their head. But yeah, I'm not a great fan of it if the alternative is a proper mediation.
I just thought I would add, I think don't underestimate the value of approaching your local MPs. Certainly mediation was in the Conservative manifesto, but it was not featured in the Labour manifesto. And the FMC have sent a draft letter to all members of the FMC that they can use to their local MPs. So it needs to be in your constituency, the MP for your constituency, just raising the issue of mediation. And I think the more mediators that do that with their local MPs, the better. It will raise the issue of mediation, and it then stands a chance of reaching what must be a very, very busy time. But I agree with Ian. I've heard no mention at all of mediation with the new government, and I think we need to get it on the agenda. Just going back to the early legal advice, which I was asked about earlier on, the MOJ were instigating that, following on from the MOJ consultation, and that was set up as a group who were a working party, which I was on, as it happens, with a group of, so I was on there as a mediator and there were lawyers on there. Unfortunately, PERDA happened, the election was called, and that group stopped meeting. And I hope, because it was an MOJ group, that that will be reinstigated. I don't actually know if the early legal advice pilot, which is funded, has got the funding in place, so it doesn't require the new government to put some money aside for it. Will be going ahead, but it was talked about the ELA, the early legal advice pilot, was going to be in two areas with a thought of expanding it out. Thanks, Michael.
The only person now I've got left on the list of attendees who's based outside the UK is Isadora. I'm not sure if Isadora is on. Are you, Isadora? No, I don't think she is. Before we just not necessarily wind down, but allow people to disappear if they want to, if when you receive the next list of anticipated attendees, if there's anything you want to add in terms of your contact details, particularly your email address, if you can let me know, because then people, when they're on, can easily make contact with other people who are on the screen. So if you want to depart, you're very welcome to. If you want to make a cup of tea and come back again, you're very welcome to. Martin